Welcome back. Now, one of the 5 suspects in the Senzo Meyiwa murder trial is still awaiting for a decision on his bail application. Accused number 2, Bongani Ntanzi, applied to be released on bail in October of last year, and he's one of the 5 without any previous convictions. However, months later, a decision is yet to be made on his application. Our senior reporter Silindelo Masikane is following that story for us and joins us live in studio now to give us an update. Slee, good evening to you, colleague. Let's get to this. Perhaps starting with taking us back to this bail application itself.
Yeah, so this bail application was really launched in the middle of the trial itself. You would remember that we began the trial. We've had stops since about April last year. And in October, his then lawyer, Bongani Ntanzi's lawyer at the time, then decided to launch an application essentially to try have him released on bail. Because according to Ntanzi, ever since his incarceration more than 2 years ago, he was never afforded the opportunity to have a bail application. And he's actually the only one of the accused who has no previous convictions and whose only pending case is actually the one that is before the courts. But what's also interesting about Bongani Ntanzi is that he is one of 2 who was actually identified through a doc identification by one of the state's witnesses who was in the house at the time of the murder, Tumelo Madlala, who of course we know to have been Senzo Meyiwa's best friend. So during the court proceedings, Ntanzi was actually pointed out by Madlala as being one of the 2 alleged assailants who were in the home on that night that Senzo Meyiwa was shot and killed. However, of course, Ntanzi maintains his innocence, maintains that he's being framed and that he needed to be released on bail because he's the breadwinner in his family. And so that application was done around the 14th of October, if I remember correctly. And since that date, I understand Ntanzi as well as his lawyer at the time have been waiting for a decision to be made, whether it's granted or even whether it's denied. 4 months later, there's still no decision. We had an opportunity to speak to the lawyer who launched the application, who now actually represents accused 3 and 4 because Ntanzi has decided to get new legal representation. But let's just take a listen to what's been done so far to try and get an answer in terms of what the delay may be.
A reasonable person will assume that between 14 days and 21 days is reasonable, and we have been waiting for the judgment. We did send a letter to the Honorable Court, and the officer was handling the bail application. Up to so far, we didn't have a response.
What are experts saying exactly? Is it normal to have bail decisions taking months on end before being delivered?
Not according to the experts that I've spoken to, because according to them, essentially when you launch a bail application, it's almost treated as an urgent application because this is somebody who obviously believes that they have, exceptional circumstances to be released on bail, and you would expect a decision to be made as soon as possible, given the circumstances around which the bail application is being launched. So according to experts, it's quite peculiar. And they're wondering whether, of course, the legal representation for Ntanzi is doing anything about it. We know that a letter has been written to the Office of the Chief Justice, and according to Tobane, he's, of course, awaiting some kind of communication in terms of what's the way forward or when a date will be set to deliver this bail judgment. Let's take a listen to one of the legal experts who was expanding on just how strange it is, really, to have a pending decision on bail for so long.
For me, it's strange because bail is not supposed to be seen as a punitive measure, but a matter of interest of justice, so that a person can actually properly prepare and conduct his or her defense or trial. And it should not, because now it seems like this person is being punished because the bail application was done and 4 months down the line, there's no decision pertaining to is bail granted or denied. Of course, we need to have some clarity.
So what's the latest then with the trial itself, Slee? Because we understand that the disbarred advocate, Malisa Latefo, has now written an affidavit to the court.
So we are on a 6-month break. Our last sitting in this trial was in November last year, and because accused 1 and 2 had acquired new legal representation, they were going to have to now familiarize themselves not only with the trial transcripts, but with the 2 dockets that are at play with this particular matter. And so the judge essentially then postponed the trial to May. That's when we are expecting the new state witness and perhaps all legal counsel to be in court so that we can resume with the trial. But at this point, I understand that disbarred advocate Malisa Latifo, who you would remember was representing some of the accused, majority of the accused at some point, he then withdrew from the matter, facing some own legal woes of himself. Since then, he's been disbarred, but has written a letter to the court basically making some of the allegations we've heard over the past couple of months from him in terms of this conspiracy by high-ranking officials to cover up what truly happened on the night Senzo Meyiwa was killed, and essentially demanding that counsel and the accused and the judge come back to court so that he can elaborate, I think, a little bit more on his allegations. We spoke to an expert with regards to how the court may actually treat this affidavit, given the fact that he's not a party to the court proceedings and he's also not representing anyone in this matter. Let's take a listen.
No, the TEFU has withdrawn as the attorney of record or the counsel on record. So he's got no locus standi, no right to appear before the judge on behalf of the parties because he's not their lawyer anymore. Number two, he can't be their lawyer anymore because he was stricken from the role of advocate. So whilst that happens, no judge will allow him to be heard. So if you don't have locus standi, you are not representing the parties. On what basis are you actually trying to have an audience with the magistrate? Or with the judge. Now, if you have to look at the letter sleeve, the interesting thing is he wants to introduce peripheral issues. Essentially, that should be ventilated to the attorney representing the accused, and that he should decide as the legal representative of those 4 or 5 accused whether he wants to make use of that information and whether it's useful.
We'll leave it there, Steve. Thank you so much for this update. ENC senior reporter Silindelo Masikane.